The envelope was sitting between a utility bill and a furniture catalog when I pulled the mail from the box on a Tuesday morning in October, and I almost missed it entirely, almost tucked it under my arm with everything else and carried it inside without looking, the way I carried mail inside every single morning on autopilot while thinking about the day ahead. Something made me stop. Maybe it was the return address. Whitmore and Associates, attorneys at law. Printed in small, precise type in the upper left corner of a standard legal envelope. The kind of type that exists specifically to communicate that the sender is a professional institution and the contents are not casual. Maybe it was the case number printed below the firm name. A long string of digits with the specific impersonal quality of something that has been assigned by a system rather than chosen by a person. Maybe it was the weight of it in my hand, slightly heavier than a bill, more substantial than a notice. The specific density of a document that has been prepared carefully by someone who prepares documents for a living. I stood at the end of my driveway in the October morning, cold with the rest of the mail under my arm and the envelope in my hand, and I looked at it for a moment. My full legal name on the front. My address. Correctly spelled, correct format. The kind of precision that means someone looked it up deliberately rather than filled it in from memory. I went inside. I set everything else on the counter. I made coffee. And then I opened the legal envelope first, before the utility bill, before the catalog, before I took off my coat. Because something in the weight and the precision of it had already communicated that what was inside was not going to get easier for waiting. The letter was 2 pages. I read the first paragraph and stopped. Then I read it again from the beginning. It referred to a case number I had never seen, a legal proceeding filed 7 weeks prior. My home, my address, my jointly owned property, listed as a proposed residence in the proceeding. My husband, Daniel Andrew Calloway, named as the primary petitioner. It was a letter from an attorney representing the interests of a 7-year-old boy named Marcus in an adoption proceeding that my husband had initiated, filed, and been actively pursuing for 7 weeks without telling me a single word about it. I read both pages standing at the kitchen counter in my coat with my coffee going cold. Then I read them a third time, slowly, the way I read things that require complete understanding. Not just the surface meaning, but the structure beneath it. The architecture of what had been built in the 7 weeks before this envelope arrived. The sequence of decisions, the appointments attended, the documents signed, the attorney retained, the court filing submitted, all of it happening in the background of our ordinary life while I made dinner and answered emails and asked how his day had been and had no idea. 7 weeks. I put the letter on the counter. I took off my coat. I poured the cold coffee down the sink and stood there for a moment looking at the drain. Then I made fresh coffee, carried the mug to my home office, closed the door, sat down at my desk, and called Margot. Before I tell you what happened next, let me tell you about Marcus. Not as a detail, not as a plot point, as the person he actually was, because that is the only honest way to tell this story. Marcus was 7 years old, and he was the son of Daniel's younger brother Kevin, and I had known him since the evening he was born. I had been in the waiting room of a hospital 40 minutes from our house on a Thursday evening 7 years ago when Kevin had called Daniel in a panic. The labor had started 3 weeks early. He didn't know what to do. His voice on the phone had the specific quality of someone who has run out of the pretense of having things handled. Daniel had grabbed his keys before Kevin finished the sentence. We drove there together. We sat in the waiting room for 4 hours on chairs that were not designed for 4-hour waits, with bad coffee from a machine down the hall and the specific suspended quality of time in a hospital when you are waiting for news. When the nurse came to tell us we could come in, I walked into the room and Kevin put Marcus in my arms before I had fully registered that it was happening. This 6-hour-old person, denser and warmer than you expect, more present than you expect, with the specific quality of complete new arrival. Someone who has just gotten here and has no idea yet what kind of world they have arrived into. No defenses, no history, entirely itself. I looked at his face. He had Daniel's eyes, even then. or what would become Daniel's eyes once they focused. I felt something uncomplicated and immediate and real. I watched Marcus grow up in the intermittent way of family at one remove. Birthday parties and holidays and occasional Sunday dinners, when Kevin's situation was stable enough for gatherings. He was a quiet child, watchful, with a way of attending to adults that went beyond politeness into something more active. He listened to what people said and then thought about it before he responded, which is not something most 7-year-olds do, and which most adults don't do either, and which I had always taken as information about his particular quality as a person. Kevin's situation had deteriorated in the specific way of someone who has been managing something poorly for a long time and has finally run out of room to continue. The details were not entirely clear to me because Daniel had always been careful with his brother's privacy in a way that sometimes tipped into opacity. He told me what he decided I needed to know, which was not always the same as what I might have found relevant. What I knew? Kevin had lost custody 18 months ago following a court proceeding. Marcus had been in foster care since. There had been 3 placements in 14 months. Daniel had visited him 4 times. What I had not been told? That Daniel had decided to adopt him. That Daniel had consulted with attorneys. That Daniel had filed a petition with the court. That Daniel had listed our jointly owned home as the proposed residence. That for 7 weeks my husband had been moving through a legal process that would change our life permanently and fundamentally, and had been doing so while sitting across from me at dinner every evening and giving no indication whatsoever. The letter from Whitmore and Associates was not an invitation to participate. It was a notification that a process had been moving without me and had now reached the point where my existence could no longer be administratively ignored. Margot Chen had been my closest friend since we were 19 years old and in the same dormitory at college, and she was now a civil litigator 15 years into a practice that had given her the particular quality of directness that this kind of work either produces or eliminates, and which in Margot's case had been present since long before she passed the bar. She told you what was true, then she told you what to do. In that exact order, without reversing them, without softening the first part to make the second part easier to hear. She answered on the second ring. "It's early," she said. "What happened?" I told her. I read her the relevant sections of the letter verbatim. The case number, the filing date, the property listing, the petitioner designation, the language about my status as a party of interest. I told her that Daniel had not mentioned any aspect of this in 7 weeks of ordinary mornings and ordinary evenings and ordinary conversations at our kitchen table, and that I had received this information for the first time 17 minutes ago, standing at the end of my driveway. Margot listened without interrupting. She was quiet afterward for the specific amount of time it takes to organize information rather than absorb emotion. Then she said, "Is the house in both names?" "Joint ownership," I said. "Both names on the deed." "And your name on the petition. Party of interest, not co-petitioner." "Correct. Which means you've been identified as relevant to the proceeding, almost certainly because of the property, but you are not listed as a consenting participant in the filing itself." A brief pause. In this state, an adoption by a married individual where the proposed residence is jointly owned requires the non-petitioning spouse to either join as co-petitioner or provide written documented consent before the proceeding can advance to finalization. Without one of those two things, the proceeding stalls. This letter is the child's attorney establishing your position before that becomes an issue. "He was going to tell me when he needed the signature," I said. Margot was quiet for a moment. "That's one way to read it. Is there a reading that's better?" "There's the reading that he was building the full picture before presenting it to you. That he wanted to have something concrete to show you, rather than an intention. Whether that's more or less charitable than the signature interpretation depends on what you know about how he operates." I knew exactly how he operated. 11 years of knowing exactly how he operated. And the thing I was sitting with, at my desk on a Tuesday morning in October, was the specific and uncomfortable question of whether what I had always called thoroughness was something else when examined in the context of a secret legal filing, that listed my home as a residence for a child I had not been asked about. "I need the complete picture before I do anything," I said. "Then here's what you do right now," Margot said. "2 names. Write them down. Dr. Irene Voss, family law, adoption specialist, 18 years of practice. She's the best I know. Call her today. Teresa Malone, child advocate. She will know Marcus's current situation better than anyone in that courtroom. Call her today as well." A pause. "And Sarah? Do not say anything to Daniel yet. I know what that asks of you. Do it anyway. A week, maybe less. Can you hold it for a week?" I looked at the letter on my desk. I thought about what it would feel like to sit across from Daniel at dinner tonight, and tomorrow night, and the night after that, with this knowledge and this silence. "Yes," I said. "I can hold it." Dr. Irene Voss's office was on the 14th floor of a glass building downtown, clean-lined and organized with the functional precision of someone who worked with documents and timelines that could not afford disorder. She reviewed the letter at our first meeting on Wednesday afternoon, asked me a series of precise questions, and at the end of 90 minutes gave me the legal picture in the organized, direct way of someone who believes that clarity is a form of respect for the person who needs to act on the information. Daniel had filed as sole petitioner 7 weeks ago, permissible at the initial stage. But in our state, finalization required documented consent from the non-petitioning spouse or joint co-petition. Without one of these, the proceeding could not complete. "He knew this when he filed," I said. "Any competent attorney would have told him," she said. "So he knew that at some point he would need my consent or my co-petition status." "Yes. And he filed anyway, without telling me, intending to obtain my consent at a later stage." "That is consistent with the timeline," Dr. Voss said, with the careful neutrality of a professional who presents facts and does not editorialize. I sat with this, with the specific shape of it, not the anger of it, which was available to me but not useful right now, but the structural reality of it. Daniel had made a decision that affected my life fundamentally and permanently. He had taken the action. He had listed my home. He had moved the process forward. And he had constructed this in a way that ensured that by the time I was informed, the alternative to consenting was no longer a clean choice. It was the choice to stop an adoption proceeding that had been in motion for 7 weeks, that involved a 7-year-old child in foster care, that my husband had been building toward for months. The choice I had been left with was not the choice I would have had if I had been asked at the beginning. "What is Marcus's current situation?" I said. "Teresa Malone will give you the complete picture," Dr. Voss said. "From the documents, 3 placements in 14 months. Current foster family has indicated they cannot offer permanency. The proceeding is time-sensitive not because of any legal filing deadline, but because of the child's situation." I drove across town to Teresa Malone's office. Teresa Malone had been advocating for children in the family court system for 22 years, and she had the quality that this specific work, done with genuine commitment over a long period, tends to produce. A complete absence of sentimentality about the process, combined with an entirely specific and personal commitment to the welfare of the actual child. Not the concept of the child, not the narrative of the child that the adults in the situation were each carrying, but the specific real person in a specific real situation who needed specific real things. She had a file on Marcus, 8 months of documentation. She went through it in order, factually, without softening. Marcus was performing adequately in school. His teachers described him as quiet, attentive, occasionally withdrawn in the way of a child who has learned that careful self-containment is safer than openness when openness has been repeatedly met with impermanence. He had one friend at his current school, a boy named Eli, and this friendship was, in Teresa's assessment, one of the primary stabilizing factors in his daily life. He had, in each of his 3 placements, made one friend and then lost that friend when the placement ended. Eli was friend number 3. He asked about Daniel during visits. Not every visit, but with enough regularity that Teresa had noted it as a pattern. He did not ask about Kevin. How does he respond to Daniel? I said. Positively. Daniel has been the most consistent adult in his life for the past 8 months. He visits, he shows up when he says he will, he remembers things Marcus tells him. She paused. These things matter more than they might seem to adults who have not experienced their absence. He asked you about Daniel's wife, I said. Whether she knew about him? Teresa looked at me steadily. He did, once, about 3 months ago. He asked it in the specific way of a child who is asking a question they have been turning over for a while. What exactly did he ask? He said, "Does Daniel's wife know I exist?" Teresa said. Not know about me, know I exist. That's a specific distinction, and I don't think it was accidental. The room was very quiet. I thought about a 7-year-old child lying in a foster family's spare room at night, turning over the question of whether the woman married to the most consistent adult in his life knew that he existed. What did you tell him? I told him that adults sometimes handle things in steps, and that the people in his life were working on the next step. She paused. It was the truest thing I could say without telling him something I wasn't certain of. I looked at the file. At the school photograph clipped to the inside cover. A 7-year-old in a blue shirt, dark hair, looking at the camera with the specific expression of a child who has been asked to produce a smile and has produced something that is technically a smile, but is also more than that, or less than that, something held back behind it. Daniel's eyes. The watching quality I had noticed when Marcus was much smaller, now refined by circumstance into something more deliberate. What does he need? I said. Teresa did not pause. Permanency. Not a good placement, a final one. Adults who are not going to revise their decision when circumstances change. A home that is his home in the complete, unconditional sense. Not provisional, not temporary, not subject to the decisions of people in rooms he is not permitted to be in. She looked at me directly. And he needs the adults in that home to be genuinely aligned. Not performing alignment, actually aligned. Children who have experienced multiple placement disruptions develop an extremely accurate ability to sense when the adults around them are not in agreement. If the adults in a potential permanent placement are not genuinely on the same page, he will know, and he will protect himself by not attaching. And if he does not attach, the placement will not hold the way a permanent placement needs to hold. She said this last part without accusation. She had read the situation from the documents. She was telling me what she needed me to understand. I understand, I said. I know, she said. That's why I said it clearly. I drove home through an October afternoon that was doing what October does. Clarifying things, stripping the softness from the shapes of things, and showing what is actually there. I thought about what Dr. Voss had told me. I thought about what Teresa had told me. I thought about 7 weeks of evenings and dinners and conversations at our kitchen table. I thought about Daniel's eyes and Marcus's eyes and the question a 7-year-old had asked his child advocate 3 months ago, lying in the bed in someone else's house. Does Daniel's wife know I exist? I thought about the answer to that question. Not the diplomatic answer Teresa had given. The actual answer. The actual answer was, Daniel's wife had been told what Daniel decided she needed to know, when Daniel decided she needed to know it, in the amount of detail Daniel decided was appropriate. The actual answer was, until 17 minutes before I called Margot, no. She had not known. I pulled into the driveway. I sat in the car for a moment. Then I went inside. Daniel was home early. This was unusual. He arrived at 6:30 on ordinary evenings, and it was barely 5. He was in the kitchen starting dinner with the specific, deliberate focus of someone doing something with his hands, because doing something with his hands was the only way he knew how to manage the waiting. I heard him before I saw him. The sound of the kitchen, the particular sounds of a person in a space they are familiar with, operating on autopilot. He heard me come in. He turned around. He looked at my face. He knew. not from the letter. I had not told him about the letter. I had said nothing. I had managed 4 days of ordinary evenings and ordinary mornings with the specific, effortful discipline of someone holding something large and important in a place where it does not show. But he could see it now, in whatever my face was doing, and I watched his expression rearrange itself into something that was not quite prepared, but was not entirely surprised either. The expression of a man who has known, on some level, that a conversation was coming and has not known exactly when. I set my bag on the counter. I set the letter from Whitmore and Associates on the counter next to it. "Tell me about Marcus," I said. He looked at the letter. He was still for a long moment. The stillness of someone who has arrived at a moment they have been simultaneously dreading and on some level needing to arrive at. Needing because the weight of the undisclosed thing had become its own burden, and the conversation that would require putting it down had started to seem less frightening than continuing to carry it alone. "Sit down," he said. "Talk," I said. He turned off the stove. He came around the counter and stood in the kitchen, and he told me. He had started the process in August, not on impulse, not as a sudden decision. He had been building toward it for months before the filing, in the way he built toward everything important. Privately, methodically, working through it alone until he understood it well enough to bring it to someone else. The visits to Marcus over the previous 8 months. The conversations with Teresa Malone about Marcus's situation and what permanency would require. The conversations with Kevin's attorney as the termination of parental rights moved toward completion. The conversations with Whitmore and Associates about what an adoption proceeding involved, what the timeline looked like, what would be required of both of us. Both of us. He had known from the beginning that it would require both of us. "You knew you would need my consent when you filed," I said. "Yes," he said. "You knew the proceeding couldn't finalize without me." "Yes." "And you filed anyway, and waited for the letter to arrive at my address, and were planning to tell me when the proceeding had advanced to a stage where you had something complete to present." He looked at the counter for a moment. "That's accurate," he said. "I know how it sounds." "Tell me how you thought about it," I said. "Not the defense of it, the actual reasoning." He took a breath. He thought about it in the way he thought about things when he was genuinely trying to be accurate rather than self-protective, with real effort, with the willingness to say the harder true thing rather than the easier approximate one. "I was afraid of your answer," he said. Not afraid that you would say no, exactly. More afraid that the conversation would make it uncertain. I had been moving toward this for months, and I was afraid that bringing it to you before I was fully certain myself would make it seem like I wasn't committed. Like I was asking you to decide something I hadn't decided, and I thought... He stopped. He started again. I thought that if I understood it more completely myself, I could bring it to you more clearly. I told myself I was waiting until I could give you a real picture. And instead, I said, a lawyer sent me a letter at my address. Yes. And the real picture I got was that my husband had been moving through a legal process involving our home for 7 weeks and had decided when I was ready to know about it. He was quiet. The specific quiet of someone sitting with something true that resists being argued with. Yes, he said. That's what happened. There's more, I said. Tell me the rest. He looked at me. You were afraid I would say no? I said. And you were afraid of what saying no would mean. Not what it would mean for the proceeding. What it would mean for us. You were afraid that if I said no, you would have to choose between your nephew and your marriage, and you were not ready to make that choice. So you built the situation instead. You built it far enough along that by the time I found out, the choice in front of me was not the clean choice I would have had at the beginning. The kitchen was very quiet. That's the part you couldn't say? I said. He looked at me for a long moment. "Yes," he said. "That's the part I couldn't say. Because saying it out loud would have required you to see what you were doing." "Yes." "And now you see it." "Yes," he said. "I see it." I looked at my husband across the kitchen. 11 years of knowing this face, the face of a man who loved the people in his life with a depth that was genuine and real, and that occasionally, in its very intensity, bypassed those people entirely. Who absorbed their decisions into his own processes. Who decided what they needed to know and when they were ready to know it. I had called this quality thoroughness for 11 years. I had made room for it. I had absorbed it and managed it and not required him to see it clearly. And I was sitting with, right now, the specific accumulated cost of 11 years of not requiring him to see it clearly. "I met with Dr. Voss on Wednesday," I said, "and Teresa Malone yesterday." Something moved through his face. Recalibration. The specific expression of a man who has just understood that he has been operating on an assumption about where things stood that is not accurate. "You've been building your own picture," he said. "I have been doing what I do," I said. "I gather information before I respond to things. I would have thought you, of all people, would recognize that." He was quiet for a moment. And then, in other circumstances, what might almost have been a very small and rueful acknowledgement of something true. "I would," he said. "I do." "Then hear what I found." I told him what Dr. Voss had told me. The legal structure, the consent requirement, what my options were, and what each of them meant. I told him what Teresa had told me. The 3 placements, the one friend named Eli, the school photograph with the watching eyes, the question Marcus had asked 3 months ago, lying in someone else's house. "Does Daniel's wife know I exist?" Daniel was very still when I said this. Very still in the way of someone absorbing something that has arrived in a specific place. "He asked that," Daniel said. "He asked that," I said. 3 months ago, to his child advocate, in the specific way of a child who has been turning the question over for a while. Daniel looked at the counter. He was quiet for a long time. And when he looked up, his face had the expression I had occasionally seen on him over 11 years. The expression of a man who has arrived at something true about himself that he would prefer not to be true, and who is choosing to sit with it rather than route around it. "I told myself I was protecting the process," he said. "That I was making sure it was real before I brought it to you. But what I was actually doing was making a decision for you, about what you were ready for and when. And that was not mine to make." "No," I said. "It was not. I should have asked you at the beginning." "Yes. And you would have..." "I would have said yes," I said. Not because a legal proceeding was already in motion, and declining would mean stopping something that had been moving for 7 weeks. Because I have known Marcus since the night he was born. Because I have thought about him in foster care for 14 months. Because the answer was always going to be, "Yes, Daniel. You just didn't give me the chance to say it." The kitchen was very quiet. Outside the window, October was finishing, the last of the light going down in the specific, unhurried way of autumn evenings. "I want to be co-petitioner," I said. "Not a consenting party. Not a signature on a consent form that gets filed and moves things forward. A co-petitioner. My name on every document from this point forward. Our decision, made together, carried forward together. We do this as partners, or we don't do it." "Yes," he said, without hesitation. "And we talk about the way this happened," I said. "Not once, properly, with someone who can help us have that conversation in a way that changes something. Because the way you handled this is part of a pattern, and the pattern has a cost, and I have been absorbing that cost for 11 years without requiring you to see it, and that ends now." "Yes," he said again. "I agree to all of that." "Then call Dr. Voss first thing tomorrow morning," I said. Tell her we're amending the petition. Both names, both petitioners, from tomorrow forward. He picked up his phone and set it on the counter where he would see it in the morning. Then he looked at me. "Thank you," he said. "Don't thank me," I said. "Be different." He nodded. "Okay," he said. "I'll be different." The couple's therapy was with a woman named Dr. Ana Reyes, who had a warm office full of plants and a quality I recognized and valued immediately. She made complicated things legible without making them simple, which is the most difficult thing to do and the most necessary. We saw her weekly for 5 months. We talked about Daniel's pattern of private processing and the specific assumption underneath it. The assumption that his certainty was a prerequisite for my participation, that the people he loved needed to be presented with decisions rather than invited into them. We talked about my pattern of making room, absorbing, managing, and the specific cost of managing something for 11 years without requiring the other person to see the cost. We talked about what the difference between trusting someone and not requiring them to be accountable looks like inside a marriage. About how a person can be genuinely loved and genuinely managed at the same time, and what it means when you finally require it to stop. These conversations were difficult. They were also the most honest conversations of our marriage. Marcus moved in on a Thursday in February, 4 months after the letter, 6 months after the secret filing, 7 years after a Thursday evening in a hospital waiting room. He came with 2 bags and a backpack, and the specific careful watchfulness of a child who has learned that the arrangements of his life are provisional until proven otherwise, and who has developed, from this learning, the precise and self-protective habit of not fully arriving anywhere until he has evidence that arriving is safe. He stood in the entryway. He looked around, at the hallway, the staircase, the kitchen visible at the end of the hall. He looked at Daniel. He looked at me. "Is this where I live now?" he said. "Yes," I said. "This is where you live now." He looked at me with Daniel's eyes, that watching quality, that processing depth, for a long moment. Not performing skepticism. Actually checking, the way you check a thing you have been told before, that did not turn out to be permanent. Then he nodded. The nod of someone who has decided to accept a thing as true and is prepared to act on that decision. He picked up his backpack. "Can I see my room?" I walked him down the hall. I opened the door. He stood in the doorway and looked at the room for a long time. The desk, the bookshelves, the window that faced the backyard where the February garden was bare and waiting. The specific pale, clean light of February afternoons. Then he walked in. He set his backpack on the desk. Carefully, deliberately, in the way of someone placing something somewhere they intend to return to. I stood in the doorway and watched him, and I did not say anything because nothing needed to be said. He was here. His backpack was on the desk. The room was his. I thought about a Thursday evening 7 years ago. The hospital waiting room, the bad coffee, the 4 hours on inadequate chairs, the nurse coming to tell us we could come in, a 6-hour-old person with surprising weight and no defenses and everything still ahead of him. I thought about an October morning and an envelope in my hand and the end of the driveway and the October cold and something that needed to be opened. I had opened it. Marcus was here. That was enough. That was precisely and completely and without qualification or condition enough.